Hello everyone, Namaste. This case is regarding Pradeep Kumar Agarwal versus Tax Office Morang. It has established principles in the condition where writ jurisdiction can be pursued in tax cases. The fact of the case was Section 10A1 of Industrial Enterprises Act 2039 granted waiver from income tax for initial 6 years of production. In the meantime, PK Chemical started production on 2041 Chaitra 4. Thereafter, notice was published in the Nepal Gazette on 2043 Baisakh 15, denying income tax exemption on dry cell battery. However, tax officer denied the tax exemption for fiscal year 2041-42 and passed tax assessment order. The applicant here pleaded that a notice issued later cannot deny the benefits enjoyed by an earlier act. The case was presented in the division bench where a justice decided to issue certiorari to quash the tax assessment order of tax office and also issued mandamus to allow tax exemption for 6 years. However, another justice differed on the decision by stating that the applicant has not taken the ordinary route of appeal and had taken the extraordinary route, so the writ should be quashed, and thereafter the case was presented in a full bench. And when the case reached the full bench, justices of full bench also had a differing opinion of 5:2 against the writ application. In reality, all the decisions of the court do not involve interpretation of law or do not propound principles or set precedents. Decisions which do not involve such interpretation and deliberation are not precedent and not applicable to individuals who are not parties to the case. Similarly, a person who has been decided guilty or is liable for punishment or liability pursuant to a judicial decision has to furnish security or guarantee for appealing to a higher authority or has to surrender for implementation of the decision is an accepted jurisprudence of our country. Accordingly, Section 34 and 57 have been formulated. If a judicial or quasi-judicial body or agency acting within the limits of authority granted by the constitutions and law passes any judicial decision which impacts property or creates a financial burden upon an individual, then merely due to such reason, it cannot be said that such decision has hijacked or encroached upon the fundamental rights of such individuals. If a decision or order of a judicial body or quasi-judicial body lacks jurisdiction, or if the law followed by such body is not in compliance with the Constitution, or if a body lacking authority attains jurisdiction, or if a decision is passed against the principle of natural justice or law, and the aggrieved party is denied an opportunity of being heard, and if such individuals pleads against such injustice in the court by invoking extraordinary jurisdiction, and if the plea is just, then the court can and must help such individuals. After reasoning for the grounds upon which writ jurisdiction can be invoked, the justices stated that the route taken by the applicant was faulty by stating following. No question of violation of constitutionality or principle of natural justice has arisen in the present application, and suspicion has been raised against the scope of authority of tax officers. It is not against Income Tax Act 2031. Such reasons are not rational and reasonable. Hence, the writ is quashed. However, Justice Trilok Pratap Rana had a differing opinion. There is no dispute that the company is entitled to exemption from income tax as per the Industrial Enterprises Act 2038. However, there is no remedy in the Act if industries are denied income tax exemption. The assessment of tax office denying exemption of income tax provided by Industrial Enterprises Act 2038 is an encroachment upon such power. Such order is void. Writ jurisdiction is available to the company in such cases. And if there is an alternative remedy, then such remedy must be exhausted. If such remedy is not effective or sufficient, then it is not necessary that such remedy must be pursued. If the appeal route is burdensome, then it becomes ineffective. The Articles of the Constitution has empowered the courts to provide appropriate remedy for imparting full justice, and the court must always be aware regarding the same. It has rejected rigidity in dispensation of justice, therefore its jurisdiction cannot be denied. Finally, we come to the conclusion that though the application was quashed, it has established principles when writ jurisdiction can be pursued in tax cases. Thank you for listening us, and please post your comments on our Facebook page or our YouTube channel. Bye! Enjoy Nepal!